Next speaker is Abhijit Iyer Mitra. Abhijit Iyer Mitra is a Senior Research Fellow, Nuclear Security Program NSP at the Institute of Peace and Conflict Studies. His research focuses on defense issues, specializing in defense economics, technology and procurement, and nuclear dynamics. He also deals with governance issues and non-traditional security threats. He has been a visiting fellow at the Sandhya National Laboratories, Albuquerque, New Mexico, and Stimson Center, Washington, D.C. Abhijit Iyer Mitra will now speak on India at 75, the need for judicial reforms.
Now I intend to commit lots of contempt of court out here. So if you don't want to get caught up in anything, there is the door. Please feel free to leave. Also, there are fantastic prizes because I decided I'm not going to give a speech. I'm going to keep this to and fro. So there are fantastic prizes sponsored by Prafulla Ketkarji of Organizer magazine. He's sponsoring a gold Cartier pen for anyone. Kanchanda will be buying a BMW 3 Series for anybody who answers my question correctly. Anand Ranganathan will be buying a Mercedes C-Class for anybody who answers my question correctly. And Shivarur, sitting at the back there, he will be buying you a Rolls-Royce Phantom if you answer my question correctly. Huh? I'm the sponsored speaker. So they are giving me. Huh. Okay. So now, we're talking about judicial reforms. First question. What makes the law the law? I mean, I can say I'm God. That doesn't make it the law. So what makes the law the law? Does anybody have an answer? Put your hands up. Just guess. Enforceable by the state. Meet Kanchanda for a BMW 3 Series. Sir. Okay. Sorry, I can't hear you. Debated and passed in Parliament. No, because anything can be debated and passed in Parliament. It doesn't exactly make it the law. Well, there are lots of laws that are not for the benefit of the subjects. But there are many laws that aren't. So, for example, the collegium system is only there for the benefit of the judges. It's not there for the benefit of the subjects. So, how does it make it the law? So, no Rolls-Royce Phantom for you. Okay. Next, anybody else? No, that doesn't make it the law. So, there are two elements of making the law the law. The first, as BMW 3 Series, Kanchanda, please meet, said, is enforceability. If nobody is there to enforce it, it is not the law, right? But that, if I take you down that pathway, that leads to police reforms. In the case of the judiciary, what makes the law is consistency. The fact that the same thing can be applied over and over and over again, which gives every citizen the knowledge that if I do this, X, Y, Z will be the consequences. There is no doubt about it. It is the consistency of law that makes the law the law. The law shorn of consistency is called tyranny. Okay? Now, today our biggest problem with the judiciary is this lack of consistency. And when we talk of judicial reforms, it's very important we go into the reasons of why are judgments so inconsistent. Between bench and bench, between judge and judge, within the same high court, within the same district court, within everything. Now, does anyone understand the concept of a negative synergy? Everybody understands? Okay, a synergy is basically where 2 plus 2 does not equal 4, 2 plus 2 equals 5. What's a negative synergy? Any ideas? Where 2 plus 2 ends up equaling 1. Okay, where you're good at your job, but your new colleague, and I'm sure every one of you has a colleague like this, they come, they sit next to you, and they're like, So you're like what your normal productivity was, it comes down very significantly. So you have a lot of negative synergies out here that lead to inconsistencies in the judgment. Let's first start with the numbers. And it's a pure numbers game to begin with. This is just the first synergy, the first problem statement, which has a lot of consequences. How many judges in India per, say, 1 million population? Any idea? Anyone? Prafulla Ketkar ji sponsoring a gold Cartier pen. Pasha de Cartier, no less. Diamond studded, sapphire studded. Nobody, okay. We have one judge for every 21 million citizens. One judge for every 21 million citizens. Do you know how many judges America has? 21 judges for every 1 million citizens. Okay. So let's start with the very basics, which is your mathematics is all wrong. You cannot improve judgment, judiciary, anything without first getting the numbers of judges proportionate to the population. Second, you come to the quality of judges. Most of your legal universities, so I'm doing I shouldn't be saying this, but I'm doing a distance education law course, which you can do. I am looking at the course material and I'm thinking, yappa, idu vandu ennappa idu? This, my dog can pass this exam. It is so rudimentary, it's a joke. There is no rationale, there is no problem solving, there is no argumentation, there is nothing. It is your typical, your 10th, 12th standard exam where you learn by rote and reproduce. 2 plus 2 equals 4, 2 into 3 equals 6, etc., etc., etc. Now, why do you need a judge? Say the law is, if you scream fire, not the law. Assume you scream fire in an open park. Is it a crime? No. But if I scream fire here, see there's a fire burning, and you all run and there's a stampede, it becomes a crime. So the context matters. Now this is a problem solving skill. In your basic judicial services entrance exam, where is the problem solving? There is no problem solving. It is, do you know which section of this, which section of that, which section of that, etc., etc., etc. So this is how you go about that. Now you are put into a problem solving situation by passing a learn by rote exam, which actively disencourages problem solving. Okay. Next, what ends up happening in all of this is, because everybody talks about lateral entry, there must be lateral entry into the IAS, into the civil services and this and that. The judiciary is one of those places where you do have lateral entry. The next Chief Justice of India, UU Lalit, is a lateral entry judge. Okay. So you can be at any point. So there are ways. You can, once you write your judicial services exam, you then go up the ranks into the High Court and ultimately, if you're deemed fit enough, into the Supreme Court. There are no clear reasons of why you should. You know exactly how it happens. I've been to jail once, I don't want to go again, so I'm not going to be very specific about it. But anyway. But you can also directly be appointed if they deem you somebody of suitable eminence. And I don't know what eminence is, but anyway. Suitable eminence, you can be appointed directly either to the High Court or the Supreme Court. Congratulations to you. If one of you are, please tell me. I will start worshipping you today so that you can pass judgments in my favor later. But anyway, this is how this whole thing happens. Now, in spite of all of this, your basic system of judiciary, what is the pool that emerges? It is your average educated person overwhelmingly from the legal services of a very rudimentary exam and a very bad education system, a very confused education system. We have fantastic people, and that is, it is a sheer function of statistics. When you have 1.3 billion people, if you don't have at least 200,000-300,000 smart people, then there is something genetically wrong with you. It is not a tribute to our education system. Okay. Now, do you all know, okay, what prize sponsored by whom now? Gautam Chikarmane from ORF will sponsor full return paid trip first class to Paris for the person who gets this right. The problem here, question, is does anybody know what the Supreme Court pendency at the moment is? Supreme Court alone, not total. 70,000. Right at the back there, very good. Gautam Chikarmane, talk to him about your all expenses paid trip. 70,000 in the Supreme Court, 4.7 crores total. 4.7 crore cases pending in total. Now, when is this going to get solved? We don't know. We have this concept of something called a pankaja. Pankaja is lotus. Panka is scum, aja, that is born of scum. Like, when you say in English, you're a scum man, punk, you're a punk. That's exactly what you say, pankaja. Why do we worship that? Why do we worship that? Lakshmi sits atop it, Saraswati sits atop it. Why? Because it is the only flower in nature which grows from scum and still emerges so pure. Because see, the truth can only emerge out of contradiction. It can only emerge out of confusion and a clash of ideas. Unfortunately, that is not how societies work. So, you talk to people, they'll say, oh, India is very corrupt, but the military is not like that. The judiciary is not like that. They are like pankaja. They are like the lotus coming out of this thing. Sociologically, that is an impossibility. Any institution of any country will be reflective of the overall sociological mean of that country. So if your country is basically lowly educated, third world, corrupt, the high likelihood is that your military, your judiciary, your civil services, your politicians are all going to be the same. It is just that some are better at hiding it, and now you know why your legal briefs are so long and written in such complicated language. Because remember, if a politician speaks the way a legal brief is written, there is no chance he'll ever get elected. If a military man ever issues orders the way a legal brief is written, he'll be shot through his head by the enemy even before he finishes dictating what is written. Okay. Now, the judiciary is very good at hiding it. But remember, these are ordinary people like you and me. There is nothing special about them. For all the flaws and things we have with our own education, with our own social setting, with our own traumas, personal traumas, interpersonal traumas, whatever, it applies to them as well. So you have an issue of pathetic legal education, a pathetic entrance exam, a low pool to begin with. And to give you an example of the pool, did you know, poll after poll after poll has found that 97% of Indian engineers are incapable of problem solving. 97%. So if any of you are sending your kids for an engineering degree, please remember that. Koi bade kaddu pe tir nahi mara hai apne. Okay. And that is not India's problem. India's problem is that 97% think that they are the remaining 3%. So they all want you to give them like multi-crore salaries every year and things like that, when they are not even worthy of producing a B-grade Maruti 800 replica. Like Kanchanda was saying before me, tell me one thing, for all our so-called software prowess, tell me one great program that you use that is Indian developed. Nothing. Do not expect the judiciary to be any different. It is a reflection. Yes, very good. Zoho, yay. It's the exception that proves the rule. Yay. Clap for Zoho. Zoho, everybody who clapped for Zoho is getting a free all expenses paid trip to Singapore. Yeah, Ku also, Ku, yay. Ku is sponsoring all expenses paid trip to Berlin. Fantastic. Now, when you have all of this, the lower judiciary is where maximum errors happen. Outright errors of judgment. And so we have a onerous appellate process, which then goes to the High Court, which then goes to the Supreme Court, etc., etc., where, mind you, technically, in any appellate process, you are not allowed to bring in new facts, new arguments. It is the case that you have presented at the lowest court which has to be heard over and over again. India is the only place where you can re-adjudicate at every stage of the process till it reaches the Supreme Court, and even at the Supreme Court, you can re-adjudicate it till you ask for a judicial review of it. Okay? Now, this all adds to the case pendency. So you have, well, how do I put this very politely to avoid going in jail? Let's say less than desirably competent judges from a very bad pool of education, racked with so many mistakes that everybody is constantly trying to correct the mistake of the other. And we're not even getting into police reforms. The moment I bring police reform as a variable in here, the negative synergies go through the roof. 2 plus 2 becomes minus infinity. Okay? And then, on top of all of this, you have corruption. You literally have Supreme Court judges who have land grabbing cases against them, outright cases of corruption against them, who were elevated without so much as even a cursory investigation. The objection to their elevation is on record. And not even the basics was done. So we come to the second problem. Where is the accountability? See, today, any of us, all of us hate some people. So you'll be like, avana paaren, avana na kolli potrano. Munji muttakos madri irukku. Okay. Now, muttakos madri, kosmalli pannradhukku seevu valya, muttakosa andha madri seevanonna. Okay. You want to grate the fellow to death. Great. What is preventing us from doing it? It is the surety that somebody is going to come and arrest me, throw me in jail, or hang me. Now, when you are sitting in a position like that, when you have exactly zero accountability, when just to get you on a charge of corruption, you have to go through the entire process of impeachment, not just by parliament, but also by the state assemblies and everything. Who is going to take the effort to do that? Too much responsibility, too little accountability. This is your second problem. Well, it's second of many problems, but this is your next problem. Now, to cap it all, thinking of 4.7 crore cases and 70,000 just in the Supreme Court, you would have thought even a basic administrative reform like paperless courts would be something you can do. No. We have judgments today that run into 800, 900, 1,000 pages. You are not writing a novel. There are many publishers who are sponsors here. If you want to write a novel, please get in touch with them. Please do not get into the judiciary. Nobody is interested in your literary skills in the judiciary. We only want our judgment. Thank you very much. Okay. But 1,000-page judgments, why? Are you so stupid and verbose that you cannot condense something that you have to say into 1.5 pages? You can't summarize something into 1.5 pages. So, the bad English that we all learned, I never understood in school why I had to learn Shakespeare. Now, everybody thinks, oh, Shakespeare is so amazing. If you think Shakespeare is amazing, there is something fundamentally wrong with you. We no longer speak the language that way anymore. Okay, it was spoken that way 500 years back. Thine eyes are shrew, lend me thine ears. I come here to not to praise Caesar, but to bury him. Who talks like that today? Why am I? Does it improve my English cognition? No. But you forget English, even Tamil or Hindi. You look at the Tamil that you're taught in school, does it bear any relation to what you have to say to get around in Pondicherry? Okay, assume you want to go buy fish in Pondicherry. மதிப்புக்கூறிய ஐயா அவர்களே எனக்கு சிறதளவு மீன் கொடுத்து விடவும் இந்த இதிலை போட்டு. Do any of you say that? No, na? You say, yo, மீன் போட்டு குடியா. That's it. So, we are taught Shakespeare and everything like that. We are not taught problem solving. We are not taught brevity. I would urge every one of you that uses Uber or Ola, I've done this in Hindi, I do this as an experiment every single time. Sir, वो जो लाल गाड़ी है, उसको पार करके right में रोक दीजिए. Pass the red car and stop on the right. On the Segapu vandiya तांडी right ले निपाटी कोंगा. ওই লাল গাড়িটা পার করে রাইটতে দাঁড়াও. Bengali, Tamil, Hindi, English, they understand nothing. Even that basic rudimentary education, he will either stop before or on the side of or whatever. He will not do exactly what you tell him to do. Try it. It's the simplest experiment you can do with your Ola or Uber driver. Try it. They will not be able to do it. So you have a linguistic problem. You know, we had to draft one law. I'm not going to tell you which law because then you'll know who the minister was or whoever. What we did was, as a think tank, we drafted a beautiful 1.5 pages, no more than 1.5 pages, and we stress tested it. We took it to every single police station to see, and we have about 4 or 5 different branches. So we did it in Madras, we did it in Calcutta, we did it in Bombay, we did it in Delhi. We stress tested it with police stations, asking them, do you understand this language? They said, हाँ sir, yes sir, ama sir, हाँ, shop gichu, okay, done. Then we took it to ordinary people on the streets, just random. There was no scientific methodology to that random testing. We asked them, do you understand it? Yes, we do. Is it easy to adjudicate? Yes, you can. Okay. So we took it back to the minister and said, sir, we have stress tested it. We have stress tested it everywhere. It is precise. It is concise. What kind of law have you given me? This is written in pedestrian English. And then when it goes before Parliament, it is 21 pages long. And I don't think my English is bad, but I needed serious help to understand what it was saying. Hereof, hereto, therein, thereof, mother of, father of, God knows what of. And this was passed. Now, मेरे को समझने में मुश्किल हो रही है. Can you imagine what a poor policeman sitting on the road, and it was one of those cognizable offenses. So he's meant to be able to make an arrest on the spot. Can you imagine that poor man's thing, how much time he has to spend just figuring out the head and tail of that law to make that arrest? Which brings me to the whole second problem, that everything has to go in front of a judge. You have this problem of cognizable offenses and non-cognizable offenses, and then you have bailable and non-bailable cases. Now, bail should be determined on one category only. One or two categories. The possibility of repeat, the heinousness of the crime, and third is the possibility of flight, that they run. But no, in India, or tampering as the case may be, in India that is not the case. In India you determine it based on the length of the conviction. If it is under 2 years, yes, you can get bail. If it is over 2 years, no, you cannot get bail. And most of these crimes are non-violent crimes. Overwhelmingly, 90% of them are non-violent crimes. So elsewhere, where you check the abuse of power by the legal system, you have to get an arrest warrant first before you arrest somebody. In India, you carry out the arrest first and then that is subjected to judicial. So the misuse of the law is not prevented, it is further taken, adding more to the caseload of your poorly educated and whatever. Okay, you get the drift. Yeah, I'm not saying it. Yeah, okay. Okay. Next, what happens is, with this pendency, it affects the quality of judgment because it affects the quality of time in front of the judges. I've literally been in court hearings where there are 2 witness testimonies being gathered in 2 different cases at the same time on the same screen. And I'm wondering, how is the judge listening to 2 different things? Is he able to, like Saraswati or Brahma, able to listen to 2 different things with his 2 different ears, or her 2 different ears as the case may be? No, they clearly can't. But that shows you the quality of listening time that the judges are giving you. Then you have this entire thing of how our law is so hodgepodge. where it creates, see, there is a common law version and there is a civil law version. So a lot of countries, in Europe, for example, even in Britain, purely because of the length of the law, most of the law is extremely detailed and it is treated as settled law. Because it comes from civil law, which is very detailed, and the judge is not meant to have too much room for interpretation. He is just meant to act as the arbiter, almost as a column checker. But in American and English law, which we have inherited, which is Anglo-Saxon common law based, the judge is both the inquisitor and the arbiter. He has a huge amount of leeway. The laws are left deliberately loose so that you leave a huge amount of leeway for the judge to interpret it. Now, I've already determined the quality of education that they're getting and their ability to problem solve. On top of this, you want the entire nonsense of a common law based thing. And even that common law, you have mangled it, because in some cases, for example, with crimes related to women, violence against women and things, you have reversed it to the Napoleonic Code. At least the one redeeming feature of the Anglo-Saxon Code is you are innocent until proven guilty. But with the Napoleonic Code, the arrest is not carried out till a major investigation has happened with extraordinary rigor, where you are deemed mostly guilty. Do you have the police to be able to carry out a proper investigation? They can't. So you keep mixing different, so you mix civil jurisprudence, you mix Napoleonic jurisprudence, you mix Anglo-Saxon common law jurisprudence, and this is what you end up with. So you have a hodgepodge like this, it doesn't work. So all the negative synergies, everything that I've been telling you is all these negative synergies building up. Now, the executive pushed back against this. They wanted to set up tribunals for everything. So, there was the Green Tribunal, there is the Telecom Regulatory Authority of India, which hears these disputes. It also frames the law, it hears the disputes and it settles those disputes. But the judiciary didn't want that. If you think 4.7 crore pendency cases is not enough for you, they also said none of these tribunals will be valid unless a judge sits on them. So it becomes a gravy train for all the retired judges. And to get onto that, you have to be extremely sympathetic to the government. And then you get onto all these tribunals. And even then, the point of a tribunal was to take basic factual disputes away from the judiciary. No, even that you cannot do. So they want to keep centralizing more and more powers to adjudicate to themselves. They go out of their way to mix Napoleonic jurisprudence, common law jurisprudence, civil law jurisprudence, so that they get the power to do all of this. And even that job they can't do properly. Next, it is not just the education of their lords that is wanting. I have several cases running. The hearing itself, if you left it, would be 30 minutes. But the hearings last something like 4 or 5 hours. Do you know why? Because 4.5 hours, you just have to sit and dictate to the fellow transcribing it, because he doesn't know English, he doesn't know Hindi, he doesn't know Urdu, he doesn't know Swahili, he doesn't know German, he doesn't know French, he doesn't know squat. He doesn't even know the pronunciation of your name, and even if you write it in front of him and put it in front of him, he still makes a mistake on it. Thank you. So, you have all these things adding up. 4 or 5 hours for a 30-minute court hearing. Judge is not able to problem solve. And then finally, last issue, is the thing of the senior advocate. So does everybody know what a senior advocate, how to become a senior advocate? Good, nobody knows. There is meant to be a criteria, but basically, to become a senior advocate, not one judge in that High Court or Supreme Court should dissent against it. Now, you all know what Margaret Thatcher said about consensus. It's a decision that nobody believes in, that everybody agrees to take because it is suitably devoid of any conviction. So this is how a senior advocate is appointed. Now, senior advocate works well in the British system, where you have a barrister and a solicitor. Okay, the solicitor does all the research and everything, the barrister does the argument in court. Here, barrister, solicitor, all the same? No, but they want to create this. Then you have senior advocates who become law minister, who have the power to make judges, whose kids very curiously become senior advocates even before they finish their law degrees, or their puppies right out of the pound. So when you have all of this happening, I want you to sit back and reflect. You know, we all talk about, oh, just the right hates Justice Chandrachud, the left hates Justice Khanvilkar, who just retired. I want you to sit and think on every one of these other points that I've given you. Most of these are solvable merely by executive fiat. I am not even going into the unconstitutionality of the basic structure judgment or the collegium that was born out of it. The collegium represents an ongoing insurrection against an, I won't say an armed, it's not an armed insurrection, but it is an insurrection against the Constitution, it is an insurrection against the law. There is no provision for it in the Constitution. Show me one place in the Constitution where it says collegium. It does not. And yet it is a legal fiction our government follows. But don't even go there. That is a very high apple to reach. I'm giving you all the low-hanging fruit. All of these are solvable through executive fiats. And yet they will not be done. And ask yourself why. Well, it's because your bureaucrats and your politicians come from that exact same pool that your judges come from. So with that wonderful IIT education where 97% of engineers can't problem solve, you have 97% of bureaucrats, if you extrapolate the numbers, who can't problem solve their things, 97% of politicians who can't problem solve their issues, and, well, the one which I don't want to invoke contempt of court. Thank you very much. So I will end here. Please meet all the respective people for your awards, the Rolls-Royce Phantom, the BMW, the C-Class, everything. Thank you very much.